Proceed to number 9. This is a proposal to amend Chapter 1616 and the regulations of the Board of Bar Examiners. Does anybody wish to speak on behalf of this proposal?
I do, Your Honor.
Very well. Please come forward to the podium.
Mr. Chief Justice and Associate Justices, I'm John Fitzgerald. I'm a USD law school graduate, December of 1979. I'm a proponent of this bill to change the bar exam back to the way that it used to be. Not to lower the standards, but to go back to the way that it was prior to the changes that were made. In essence, the changes that were made were that the cut score was raised 5 points. That had some effect. But the biggest problem was that they disallowed the averaging of the MEE and the MBE components of the bar exam. And by not allowing persons to average those two components of the test, we have caused South Dakota to now be second to the last. Only California has a lower rate of failure than South Dakota does on the bar exam. Thank you.
Thank you, Mr. Fitzgerald. Other proponents of the proposal? Mr. Leach.
May it please the court. I came here today for 3 reasons. And the first of those 3 reasons arises from my service on the Board of Bar Examiners from 1997 to 2009, the last 6 years of which I was the chair. During that time, our passing grade was 130, and the scores on the 2 parts of the examination were average. So a 128 on one and a 131 on the other, a 133 on the other would get you in because your average was above 130. The 130 did not come in 1997 when I went on the bar exam. When I went on bar examiners, it was in place for some time before then. I just can't tell you how far back. But during that 12 years in which we administered 24 bar exams, 2 a year, we passed an awful lot of people who scored 130, 131, 132, 133, or 134. And I can't tell you that there was never a session in which we did not have someone at one of those 5 scores, but I can tell you that if it was a true oddball, because at least virtually every session we had someone at one of those 5 scores. Counting back now, 1997 when I went on the board was 21 years ago. 2009 when I got off the board was 9 years ago. So we have a whole group of lawyers who have been practicing between 9 and 21 years, and farther back also, who got in with scores combined between 130 and 134. And to my knowledge and belief, we do not have a problem with incompetent lawyers in South Dakota. I look at the disciplinary board statistics every time they come out for the in the little booklet that comes out before the bar convention, and incompetence is not a real high number of complaints given the number of lawyers in this state. I think there's a reason that we don't have a problem with incompetence from having been at 130, and that's because I don't really think the difference between 130 and 135 on a bar exam means much. And I say that because what's required to practice law competently and well is darn hard work, dedication, and caring about what you're doing. I remember when I came out of law school, boy, I thought I really knew a lot. And frankly, I took 3 bar exams in my first 3 years in 3 different states, including California. I passed them all. You know, I thought I was pretty smart. All it took was my first job for me to realize that I actually knew very, very little about practicing law. And what I always told people, when they'd ask me, I say, I learned about 15% of what I know what I need to know to practice law in law school. And I think it's probably that 15% that's reflected on the bar exam. I don't need to know anything about real estate or trusts or wills, real property. I never have, because I've never practiced in those areas. I've never studied those areas. And so I think the people who score between 130 and 134 deserve a chance. I don't think the bar exam is that sharp a tool in terms of who can and who cannot be, and who will and who will not be a competent lawyer. I am in favor of combining
you
the
are?
two scores, absolutely.
Okay.
So you're favoring a cut score on the MBE of 130 and averaging of the two components?
I'm favoring a total score of 130 computed by taking one score, adding the other score, dividing by 2, which is how we did it for the 12 years I was on the bar examiners. The second reason is the effect that this change will have on Native American applicants. And this is an issue, the paucity of Native Americans in our bar that I've worked on for several years with the last several bar presidents, as well as with other concerned lawyers in South Dakota. I think you've probably heard the numbers that, as best we can estimate, we think there are about 30 Native American lawyers in South Dakota, and that's approximately 1% in a state in which there's a population of 10%. And in western South Dakota, I'm told that approximately half the cases that are filed involve Native Americans. We need to do something to make the bar, to try to make the bar more reflective of the population. And this is not going to come slowly, and making this proposed change is not going to solve the problem, but it will allow another Native American to become a lawyer here and there. And when you only have 30, everyone counts. So why do I say that this would have an effect on Native Americans? What's my evidence of that? My evidence is that from being on the bar examiners and reading the National Conference of Bar Examiners publication every time it came out, Native Americans, along with other minorities, score lower on every standardized test in the world. Early childhood tests, SATs, ACTs, LSATs, MCATs, they just score lower. And the reasons are really not in dispute. It's because minorities, including Native Americans, by and large, on average, not everyone, but on average, they have parents who have achieved less in school. And how far your parents went in school is the biggest single predictor of how far you will go in school. And they tend to attend, on average, not always, but on average, schools that are not as good as the schools that non-Indians attend. And so this is another reason why I think that this would be a good change, because we're just going to have here and there another Native American in the bar, and that's a good thing. Thank you all very much.
Any other proponents wish to speak? Rush.
Thank you, Mr. Chief Justice. I'm Art Rush. I'm a state senator from District 17, which includes Vermilion. Obviously very concerned about the future of the USD Law School. The fact that South Dakota, right in conjunction with that, raised their requirements for bar passage. I'm not going to try to tell you how many people that directly affected or what percentage of the failures that impacted, but seems to me that one of the steps we could do in conjunction with the effort is go back to the old method that we had of scoring that, and would appreciate your consideration of that. Thank you.
Thank you, Senator. We appreciate you coming. Dean Gewey, are you going to speak?
My name is Tom Gouy, and I am Dean of the Law School, but I appear today as an individual member of the South Dakota State Bar. I do not represent the Board of Regents, nor do I represent the university. I am familiar with what has gone on in the law school, and I've watched the bar exam carefully. One of the changes in the bar exam, if you look longitudinally over time, is that it is, the questions are much longer. The essays used to be about a half page. Now they're about 2 pages, or about a page. They are multiple issue. They used to be single issue. The essay exam or the multiple choice portion of the exam also has longer fact patterns. It now has Civ Pro as part of the exam, which adds another subject to the multiple choice, but the Civ Pro has always been part of the essay, but multiple choice gives it a few different things. One of the things that I believe have happened over time with the product of the National Conference of Bar Examiners is that they've become very concerned about reliability. And reliability statistically means you've got to have a right answer. Once the Supreme Court of South Dakota decides 3-2, then there's a bright line rule. But if they present a fact pattern that is going to go 3-2, then if one answers with the minority, they're still 40% right. And that hurts reliability. So what they've done is they've gone to, I believe, a straighter linear logic and far more memorization and of bright line rules. We all know that bright line rules are problematic.
If not, thank you for coming, Dean. Mr. Speaker, welcome.
Mr. Chief Justice and Associate Justices, to the extent I'm here advocating to consider a rule change, you know, the law school has a difficult task. It's in a small town in a small state, and it gets by with relatively inadequate funding. And so it's important that we have rigorous standards, but we don't need to make the hill any steeper for them. If there are 47 other states that allow averaging, I would encourage you to consider at least that portion of the rule change. Thank you.
Thank you, Mr. Speaker. Other proponents?
Good morning, Chief Justice, Associate Justices. My name is Eric Witcher. I'm the Director of the Pennington County Public Defender's Office. We employ 19 attorneys, including myself, in our office, and on average, we hire about 3 young lawyers each year. And add to my written comments is the human toll that this puts on these young attorneys. And we've had 2 young lawyers not pass the bar here in these last several exams. And I watched them both, and I don't believe that this is just a USD issue either. Both of these attorneys, one was a graduate of University of Michigan, top 25 law school. The other was the University of Nebraska, also a very highly regarded law school. Both graduated undergrad with cum laude. And as I watched them getting to practice under the special rules as law students, you know, they were spotting issues and advocating effectively in front of the court. And they seemed like bright young lawyers, so I was surprised when they didn't pass. And they're also, you know, have incurred $150,000 in debt or more through their law school career. And so it's a real burden for them. So I would advocate for the changes based upon those reasons. Thank you.
And that, opponents. Public Defender Fulton.
Mr. Chief Justice, Justice of the Court, thank you for the opportunity. I'm Neil Fulton. I'm a lawyer here in Pierre. I'm the Federal Public Defender for North and South Dakota. And I'm also a member of the Board of Bar Examiners. Nobody is owed a law license. It's a privilege. It's a responsibility. And there is an important role for policymakers to set a level of minimum competence. And I would ask the court this final question, because one of the other facts I thought about when we think about do the facts and the policy align is, what about the arguments presented by the proponents doesn't apply to moving the cut score to 125 or to 120 or to 115? 135 is, as we point out, the national average cut score. But one of my friends and I talk about baseball, and there's always somebody who's not in the Hall of Fame. There's the second baseman with the most RBIs on Tuesdays batting left-handed. There's always a case that you can make for the person who's just outside a cut score, and there will always be people outside cut scores. But a cut score exists to provide minimum competence.
Other opponents, Judge Sabers.
May it please the court.
I don't know what I was asking, but I do have another question.
Okay.
Your explanation on the scoring, that helps. But my question at this point is, and maybe the UBE explains part of this, but as I understand it, we're only one of two states that doesn't do the combined scaling. Is there a reason why other states have chosen to go the other direction, or most states have, other than the UBE?
I think so, but to say there are only 2 states that don't do the scaling is not entirely accurate, and I know that's the number that's thrown around. There are other states that scale on their own. I believe it had lunch with the Michigan contingent once. They ran the scaling formula by their professors of statistics at their local university. They didn't much care for it. They drafted their own. So there are other groups throughout the US that are scaling, but not scaling per the NCBE necessarily. So that number's higher. I don't have that number for you, and I apologize. But I do remember what your question was. It was the reciprocity. It was the retroactivity question.
Yeah, right.
No, we can't do it.
Yeah.
We cannot do what they ask. And Justice Kern, you had asked about the posting. I have a somewhat complicated chart here. I can boil it down to this. If the questions are publicly available, NCBE puts them on their website. If the grading materials are publicly available, NCBE will sell them to you. We have very limited opportunity to hand out the NCBE grading materials. Those aren't ours. We don't own them. We promise that we will not misuse them when they agree to share them with us. When I send back my grades to peer, I send back those grading summaries. I don't even keep those in my own office because they don't belong to me. They are simply on loan. I have a chart here that talks about, and some states do post some materials, and these are terms of art for the national conference. The national conference will allow the release of some but not all. The MEE, the essay grading guidelines, and that means a certain thing. The essay grading guidelines and the performance test model answers, grading guidelines, and grading summary are not for public distribution. They don't post them, they don't sell them, they don't provide them. When we as graders get to look at them, we have to promise that we will not use them for public distribution and will not let them out of our sight. National Conference runs business. They sell you tests and they sell you grading guidelines. What they believe is appropriate for public distribution would be equally appropriate for public distribution at our level. When students will say to me, could I look at tests? I say yes, go to the National Conference website. Anything that is free is there. But some states will allow a student with a failing paper to come to look at that paper and to discuss why that paper is a failing paper. And to the extent allowed by the chart, if the student is given permission to look at the grading guidelines, then they could look at the grading guidelines at that time, not take them away, but do that. We've never done that. It's a manpower issue. We're a volunteer board for what I hope you all recognize as a remarkably thankless position, but we're a volunteer board, and it's in part a manpower issue. But we spend hundreds of hours a year studying this, and we think our proposed changes several years ago were the right thing. I am disappointed that our LSAT scores are down. I am disappointed that our pass rate is down. Kids stopped going to law school, and some of the kids that stopped were the brightest kids we had to offer. It's unfortunate, but it's not the fault of my board.